Welcome to our webinar today. I'm Melanie Pimenta.
And I'm Jacob Montague.
Today we will be discussing the format of IDTA's Cybersecurity and Artificial Intelligence. Firstly, we'll consider what IDTAs are and then consider how your organisation can implement IDTAs and circumstances where it is appropriate to do so. Following the binding judgment in Schrems II, which I'm sure you all recall hearing about, the IDTA and addendum replaced standard contractual clauses for international transfers. The UK GDPR requires companies that transfer personal data from the UK to a third country that is not considered to offer adequate personal data protection to implement safeguards for the protection of personal data subject to the transfer. These requirements mirror those under the EU GDPR. So, when did the IDTAs come into force, Jacob?
Well, on the 28th of January 2022, the government laid before Parliament the International Data Transfer Addendum to the European Commission's Standard Contractual Clauses for International Data Transfers, also known as the addendum. This also included a document which set out further provisions. As no objections were raised, these came into force on the 21st of March 2022. Consequently, the ICO published a suite of documents consisting of the draft IDTA, the addendum, and the transitional provisions that could be relied on immediately, i.e. from the 21st of March 2022. The next element to consider is when you are required to start using them.
Well, organisations can use the IDTA immediately, as these have been in place since the 21st of March this year. The transitional provisions gave a grace period before the changeover to IDTAs becoming mandatory, and this will largely depend on the type of transfer of personal data. All signed agreements that were concluded before the 21st of September 2022, based on the old EU standard contractual clauses, can remain in place until the 21st of March 2024, provided that the processing operations under the relevant contract remain unchanged and the transfer of the personal data is subject to appropriate safeguards. So finally, all contracts involving the international transfer of data from the UK will need to incorporate either the IDTA or the UK addendum. So we would strongly recommend reviewing your existing data protection arrangements and identifying those arrangements which will need to be renegotiated by the 21st of March 2024. So, how are these different from the previous standard contractual clauses?
Well, as you mentioned earlier, the decision in Schrems II triggered a reaction from the ICO and a decision to conduct a public consultation on how organisations can continue to protect an individual's personal data when it is transferred from outside the UK. Following a further consultation by the ICO on its proposals to update its guidance and the terms available to organisations for safeguarding transfers of personal data from the UK to third countries, the Standard Contractual Clauses, or SCCs, were updated to reflect the requirements of the EU GDPR and to make them more flexible to use. This includes a recognition of transfers from processor to processor, but also processor to controller. Now, the ICO has provided guidance on how the IDTA should be completed. However, it must first be remembered that the IDTA only covers the restricted transfers of data, and so it does not cover other aspects of the relationship between a company and the importer. For example, you may already have a service agreement or a data sharing agreement in place between you and an importer, and these linked agreements are often very helpful and useful in finalising the information required to be completed in the tables in the IDTA. And in that case, you can just refer to the relevant section of the linked agreement. Next, prior to implementing the IDTA, you will have to consider whether you need to carry out a transfer risk assessment.
We were expecting further guidance following the implementation of the IDTA and addendum to be released this autumn, and I'm pleased to say that only in the last few days the ICO has provided this guidance, which includes a new section on transfer risk assessments and a TRA tool. The ICO has confirmed that there are two approaches to conducting a TRA, the first option being the ICO's approach in its TRA tool, which you can see on the screen now. In this tool, the ICO has set out a 6-question approach, which consists of considering what the specific circumstances are of the restricted transfer, what the level of risk to people in the personal information you are transferring, and what a reasonable and proportionate level of investigation is with consideration of the risk, amongst other factors. The second option is the approach taken by the European Data Protection Board. Broadly, this is an assessment where the laws and practices of the UK, which includes the UK GDPR, are compared to the laws and practices of the importing country in order to assess the risks as shown on the screen. So this leads on to our next question. What is a transfer risk assessment? A transfer risk assessment enables you to make a restricted transfer when you plan to rely on one of the Article 46 transfer tools, such as the IDTA. It helps you ensure that the Article 46 transfer tool provides appropriate safeguards in the particular circumstances of your restricted transfer. So the purpose of this is to ensure that you check whether, for your restricted transfer, taking into account all the circumstances, the IDA provides protection for the data subjects, which is sufficiently similar to the relevant protections they have when their data is in the UK. So the key aspect here is ensuring that only those parts of the destination country's regime which are relevant to your restriction, so not the whole regime of the destination country, offers a sufficiently similar level of protection to the protections offered in the UK GDPR. As part of the transfer risk assessment, there are many factors to consider that relate to the restricted transfer itself. For example, the type of personal data transferred, the type of entities involved in the transfer, the method of transfer, whether the data will be stored outside the UK, or whether there is remote access to data stored within the UK, amongst other factors. In addition, you will need to obtain particular facts about the destination country and consider these in the risk assessment. These will include, for example, whether there are partial UK adequacy regulations in relation to that country, its human rights record, its legal and court system, and how close it is to the UK legal and court system, amongst other factors. The third aspect to consider is the potential impact on the data subjects of the transfer and any risk of harm to the data subjects that you identify. The overall aim is to enable you to decide whether the IDTA on its own provides appropriate safeguards for your restricted transfer, or whether you will need to take extra steps and protections. The ICO advises that if the data is very high risk, the IDTA and transfer risk assessment should be reviewed at least once a year. So if nothing has changed, then the review will be very straightforward, but it is still important to check that nothing has changed.
So we've already touched on the UK addendum to the new EU standard contractual clauses. But what is this document, and in what circumstances should it actually be used? So the UK addendum is designed to be used either as a standalone agreement that incorporates the relevant parts of the EU contract and EU standard contractual clauses, for example, because an organisation is already used to contracting on the basis of EU SCCs and wants to do that for its UK data, or in situations where personal data from both the UK and the EU is being transferred to the US alongside EU data, which would be separately governed by the EU SCCs. An example of this might be that you have a global entity who is transferring personal data from a number of EU states plus the UK to the US. In theory, the company could enter into one set of EU SCCs along with the addendum for the UK data. So, taking a look at the addendum, we can see that Table 2 shows you that you have the option to choose either to specify an identifiable EU SCC's agreement or to incorporate relevant modules. Moving to table 3, we can see that you are allowed to set up where the appendix information is located. And again, this could be by reference to a set of existing EU SCCs, a master agreement, or you could add a specific schedule to the addendum if using it standalone. However, you will need a separate EU SCCs in conjunction with the addendum, so you cannot avoid having two documents. Now, the reason for this is because the EU SCCs need to be entered into as is and signed, and the addendum would not be sufficient, as it disapplies certain provisions and changes the governing law, to name just a couple of these changes. We can also see that from clause 11 also states that where this addendum incorporates addendum EU SCCs, which have been entered into to protect transfers subject to the General Data Protection Regulation, then the parties acknowledge that nothing in this addendum impacts those addendum EU SCCs. Therefore, this preserves any set of EU SCCs to avoid them being invalidated.
So, to consider what this means for now, up until 27th of December 2022, controllers and processors can continue to rely on those earlier SCCs for contracts that were concluded before the 27th of September 2021, provided that the processing operations that are the subject matter of the contract remain unchanged. And following the 27th of December 2022, these agreements will need to be transferred to the new EU SCCs and addendum. So, as mentioned earlier, you should review your existing data protection arrangements and identify those arrangements which will need to be renegotiated by the 21st of March 2024. So this concludes the discussion on this topic, and just wanted to say that we've recently advised clients on implementing IDTAs and can appreciate how difficult this can be when considering the different types of factors and data involved. So we would be happy to provide specific advice on such agreements if needed.
So, moving to the second topic of this data protection webinar, cybersecurity. So, as I'm sure you're all aware, cybersecurity continues to be a hotly discussed topic and affects more companies than you might first expect. According to recent surveys by IT Governance, there were 1,243 publicly disclosed security incidents in 2021, and this accounts to close to 5 billion breached records. This represents an 11% increase in publicly disclosed security incidents compared to 2020. A further study by the UK government also highlighted that within the group of organisations reporting these cyber attacks, 31% of businesses and 26% of charities estimated that they were attacked at least once a week. And I think there are a lot of assumptions made by companies, particularly those in the professional services world, that, oh, it won't happen to me, or I'm not the kind of thing that hackers are looking for. But actually the reality is that all businesses are susceptible to attacks. And I think the recent ransomware attack on Tucker's solicitors has proved a very useful case study in this regard. So, back in August 2020, Tucker's solicitors became aware that there had been a ransomware attack on its systems and that this had resulted in a personal data breach. Tucker's did act quickly, and once discovered, the firm did report the breach and shut down their internal systems in order to prevent any possible further access. Unfortunately, this was already too late, and the attack resulted in the encryption by this malicious and criminal attacker of close to 980,000 individual files, and of which 25,000 of those related to court bundles. This obviously compromised, very sensitive personal data, and actually also special category data, which includes racial and ethnic origin, political beliefs and opinions, religious beliefs, trade union membership, genetic data. And naturally, given the nature of the data that had been exposed by the hacker, the Information Commissioner's Office launched a full investigation and subsequently fined Tucker's £98,000 for their failure to implement appropriate technical and organisational measures over some or all of the relevant period, which had left them vulnerable to this attack. Now, the ICO highlighted two key areas where they felt Tucker's were particularly vulnerable.
Yes, so the first relates to software updates. We have all seen those computer requests asking us to restart the computer so that software updates can be installed. We know when it says estimated time of 3 to 4 minutes, it usually means 10 to 15 or even longer, and we always try to put that off. Well, in January 2020, the provider of Tucker's cybersecurity software published an alert stating that they had discovered vulnerabilities in its network and then therefore released an update that should be installed as soon as possible. The alert and the update were described as critical, meaning that the guidance was to install the update within 14 days of release. Tucker's did not install the update until 5 months later, in June 2020. As part of the Commission's report, they further noted that this went against practices detailed in Tucker's own data protection policy, which states all software, operating system and firmware shall be updated on a regular basis to reduce the risk presented by security vulnerabilities. So some may be thinking that this may have had little consequence, as the attack took place a couple of months after the software was updated. However, research suggests that this early infiltration is a common tactic used by advanced threat groups so as not to alert the company to its own weaknesses. The second point of contention was Tucker's lack of multi-factor authentication, or MFA as it's commonly known. This has been recommended in particular by our own regulator, so the Solicitors Regulation Authority, since 2018. Without MFA in place, the ICO concluded that entry to systems holding personal data could be gained solely through the exploitation of a single username and password. The ICO further commented that MFA was a low-cost preventative measure, so that should have been implemented. So, what can we learn from this, and how can you implement effective practices?
Well, according to another recent government survey, only 19% of businesses have a formal incident response plan. And while only 39% have an actual assigned role should an incident occur. So in contrast, however, most businesses show a clear reactive approach when breaches occur, with 84% of businesses saying that they would inform the board, while 73% would make an assessment of the attack. And I think that this is what's very interesting about it, is that it's the lack of proactive steps that seem to be where businesses tend to be most vulnerable. So with that in mind, here are our top three. And I think first and foremost, a comprehensive risk assessment should be undertaken to assess your vulnerabilities, but also to understand where your valuable assets are. This is likely to include the personal data of clients, customers, financial data, intellectual property, business critical systems such as email or document management systems, or any other commercially sensitive data. And understanding and identifying your valuable assets, i.e. which need the most attention, will allow you to better mitigate the risks attached to them. Businesses should consider how these valuable assets are assessed, how they're stored, and also their dependency on external services, third parties, and even the supply chain.
That's a good point. And secondly, so companies should give appropriate weight to employee education and awareness. The Information Commissioner recently commented that the biggest cyber risk businesses face is not from the hackers outside of their company, but from complacency within the company. So these comments came after the ICO fined a well-known UK-based construction company $4.4 million following a data breach caused by employees. The breach resulted from an employee forwarding a phishing email to a colleague. The colleague opened that email, which contained malware that installed itself on the employee's computer. So subsequently, the personal data of over 100,000 current and former employees was compromised. Businesses should establish staff training programs to help employees identify malicious or suspicious communications. These should also be supported by regular internal campaigns promoting effective security awareness that will help foster a positive incident reporting culture.
So, the final tip. We believe that businesses should ensure they have an incident management strategy in place as essentially as mandatory. It's crucial to this strategy that you will be establishing an incident response team, ensuring that they are known to the wider business, but also ensuring that they have the requisite knowledge and training to respond to incidents.
So, we want to conclude our webinar by briefly touching on artificial intelligence. This is all up and coming at the moment, and we're just going to look briefly at the UK's approach and anticipated regulation. So AI has many official definitions, but we can loosely be described as the technology that enables machines to learn from the data and therefore perform tasks normally performed by human intelligence. So AI and its place in our society often garners opposing views. Many see it as crucial to our continued survival on this planet, as it could lead to faster innovation, greater efficiency, and exposes human error and bias. Others are wary of the moral and social consequences of having a technology on machines that can think independently and want heavy regulation.
Yeah, I think I'm probably in the latter camp. I'm slightly wary of it, and it's an interesting topic and one that is constantly in the media. I'm sure we all remember this summer story regarding a well-known web browser engineer who was allegedly put on leave for describing one of the company's chatbots as sentient, with thoughts and feelings equivalent to those of a human child, which is quite scary. But regardless of your views, I think we can all agree that the technology is here. It's rapidly expanding, and it's likely to play a role in almost everything we do in the future. Unsurprisingly, AI is particularly crucial to the ever-expanding metaverse. Now, for those of you who aren't aware what this is, the metaverse describes virtual worlds which essentially allow people to do pretty much everything. Work, talk, game, shop, without ever leaving their homes. Now, there are already many of these virtual worlds in existence, and such is its rapid expansion. A number of key professional services, from banks to lawyers, have already set up offices in the metaverse in anticipation of future work and clients. Decentraland is an example of a metaverse which counts a number of top European law firms as its users, and it's actually recently reported that the value of its virtual real estate is somewhere in the millions of dollars. And of course, AI's role is essential to the success of the metaverse because it will be used to populate its avatars, its digital humans, learn from its users, process and predict transactions and interactions, all essentially in order to provide the best experience for these users.
So keen to harness this technology's potential and cement itself as a leader in AI governance, research and innovation back in September 2021, the UK government published its national AI strategy. So key to this, there will be the government's approach to regulation. And as part of this strategy, the government released a further policy paper titled Establishing a Pro-Innovation Approach to Regulating AI. So currently AI is not regulated as such, and this sparks concern amongst commentators, especially considering AI's growing role in the way we live and operate, as you explained earlier, Jacob. Instead, the technology is partially regulated through other legal frameworks and requirements that capture uses of AI technologies as a byproduct, and this includes the UK's data protection laws that govern automated decision making. So as mentioned earlier, regulation is at the heart of those most concerned about AI potential, and the UK faces an interesting balancing act in order to provide adequate regulation whilst not stifling potential, their onerous red tape and obligations.
Absolutely. And from reviewing the policy paper, we can see that as a starting point, the government intends to ask regulators to apply the following core principles in their sectoral domain. So firstly, they want to ensure that AI is used safely, understandably, and the policy paper does state that it's going to be a context-based approach that will be adopted here. We can expect that sectors such as healthcare or infrastructure will require a higher threshold. Secondly, they want to ensure that AI is technically secure and obviously functions as designed. I think this largely relates to security, and the paper actually requests that regulators set out their regulatory expectations in their corresponding sectoral domain.
Yeah, so thirdly, ensuring that AI is appropriately transparent and explainable. The policy paper believes this will be particularly relevant in high-risk settings where the decision-making process and consequence must be capable of being readily explained. And finally, ensuring clear definitions for the legal person's responsibility for AI governance. The paper affirms that the outcomes produced by AI systems must always rest with an identifiable legal person. So we envisage some harmony amongst the regulators. However, be prepared for varying definitions. Fairness and transparency in an AI context are unlikely to give more weight in certain sectors than others. A further white paper is expected early next year, and we will endeavour to keep you updated with any further developments.
Absolutely.
So, thank you for attending our webinar. We would be happy to assist if you require any specific advice on these topics.
Thank you very much.
If you have any questions at all, please contact us.